Welcome to this episode of People's Law. I'm your host, Bob Coco. I've been a practicing lawyer in Philadelphia for over 20 years. Most of that time I've specialized in consumer protection law, an area of law that is not very well known to the general public, like, for example, personal injury law. So my goal on this show is to improve the average person's basic knowledge of the laws that most affect their daily life, but which they may not be aware of or just need to understand better. To do so, I'll have guests from the legal community provide you with useful information to protect your legal rights in different areas of civil law and criminal law. In our show today, we will be discussing some timely legal topics in the area of criminal law, the new medical marijuana law in Pennsylvania, and prosecution of marijuana laws under our new district attorney, Larry Krasner. And we will also discuss automatic license suspensions for drug arrests. And to help us understand the developments in criminal law regarding first marijuana use, we'll hear from criminal defense attorney Michael Nisnik. So let's introduce our first guest. Michael, welcome to the show.
Thank you for having me, Bob.
So in a lot of states now, marijuana use is widely legal, but in Pennsylvania, it's still restricted. And one area we want to talk about is medical marijuana use.
Yes, in Pennsylvania, medical marijuana is now legal. It was signed into law in 2016 and became available to the general public, well, to the public who has a medical marijuana card in 2018. It is not legal recreationally, as it is in many states, but it is available with a doctor's written prescription. And
you mentioned a card. Is the card equivalent to a license that one would obtain to use it legally?
It is. So to obtain a license for a medical marijuana card, you must be diagnosed with a qualifying condition. Examples of qualifying conditions would be chronic pain, PTSD, cancer, terminal illness. There's quite a long list of qualifying conditions. Once you have a qualifying condition, you must go to a state-approved doctor, and that state-approved doctor will then prescribe you a medicinal marijuana card.
Is there any privacy concerns that attend acquiring this license or having one of these licenses?
Certainly. Privacy concerns, I think, are prevalent, especially with an individual who is seeking a medical marijuana card, but perhaps their job may not permit the use of marijuana for whatever reason. And it's important to know that the access and the obtaining of a medical marijuana card is covered under HIPAA law, so it is confidential.
Okay, so one doesn't have to worry about your employer or anyone you don't want to know about it.
That's correct. Your employer should not be able to access your personal medical information the same way they wouldn't be able to access your information that you gave to your doctor at a normal doctor visit. They should not be able to access your medicinal marijuana information.
How about insurance issues for it? Is it covered by insurance?
Typically, under most insurance plans, medicinal marijuana in Pennsylvania is not covered. The reason for that is marijuana is still illegal under federal law, so insurance plans have just said they will not cover it. So it would be an out-of-pocket expense for someone seeking medicinal marijuana.
Okay. And moving outside the topic of medical use of marijuana, there has been some changes in Philadelphia, though, with regards to the marijuana laws, or maybe more accurately, the enforcement of marijuana laws. Maybe you can help us understand that a little bit better.
Sure. So the new district attorney has scaled back the prosecution of marijuana-related offenses. I do a lot of criminal work in Philadelphia, and I've noticed that the district attorney's office will still prosecute marijuana-related offenses when it relates to the sale or distribution of marijuana, which is considered a felony under Pennsylvania law. But for the simple possession of marijuana in Philadelphia, they have scaled back their prosecution drastically, to the point that by law in Philadelphia, it's now decriminalized to simply possess marijuana. I believe the possession of marijuana in Philadelphia would entail a $25 fine, and the act of smoking in public of marijuana would entail a $100 fine, which is considered a summary offense, not a criminal offense.
Okay, summary and the difference between those, a summary offense, you would be essentially fined. Is there any danger of incarceration for a summary offense?
There is. A summary offense can carry with it up to 90 days of incarceration at a max. But I'll tell you, as a practical matter, it's very rare to see a summary offense turn into an incarceration matter. Typically, a summary offense would carry with it just a fine, maximum being $300. Now, one thing to keep in mind is the summary offense would be on your background check, for lack of a better word.
Mm-hmm.
Not necessarily your criminal background check, but an employer could access the offense if they ran the correct background check. Now, a summary could be expunged off your record within 5 years, but it would be accessible.
Okay. Unfortunately, we've covered a lot of those topics in a prior show, so I won't have to have you speak to them here today.
Sure.
But let's stay on the topic of drug convictions, and in keeping with theme of the show, an issue that people may not be aware of, and that is the impact of drug convictions on their driver's license. And even if there's, I think you'll explain to us, even if it's not a driving-related offense, a drug conviction can impact your driver's license privileges.
Yes, that's true, Bob. In Pennsylvania, if you're convicted of a drug-related offense, whether that is a misdemeanor possession of a narcotic, or a felony-level possession and with the intent to distribute, the traffic laws allow PennDOT to suspend your license. So even if you're walking down the street and you're stopped with marijuana, a completely non-driving related offense,
right,
PennDOT can still and will suspend your license if you're convicted of that offense. The suspension is typically, for a first offense, 6 months of a driver's license suspension.
Wow. Is there any defense that one could have to such a charge if it's brought?
Well, if you're convicted of the drug offense, by law, PennDOT will suspend the license. Now, there is a few things that you can do with the charge itself before it becomes a conviction that would allow the offense not to be considered a conviction.
Okay.
For example, you could participate in an ARD program or a Section 17 program, both of which are considered diversionary programs, and they would allow you to avoid a license suspension.
So let's talk about each one of those that you just mentioned. An ARD program to prevent a conviction. Let's talk about that first. What's that?
Sure. So an ARD program is a program. Typically, it's reserved for DUI offenses, including DUI offenses that involve marijuana. And the ARD program allows a defendant to participate in a period of probation, a few classes, driving-related classes, to pay a fine, and provided they don't get in trouble during that period of probation, the charges would be withdrawn and then expunged from the record. Now, it's important to note on the license suspension issue that depending on your BAC,
What's that?
The blood alcohol content.
Okay.
Whether that's alcohol or drugs, there would be a small license suspension associated with the ARD program.
Okay.
That's different from the PennDOT license suspension for a drug possession.
Okay. All right. And now let's just clear up the acronym ARD as well, like we just did with the blood alcohol. So ARD stands for?
ARD stands for Accelerated Rehabilitative Disposition Program.
Okay. And in addition to ARD, you mentioned Act 17?
Yes.
Okay, let's talk about what that is.
Sure. So under the Section 17 program, it's essentially an ARD program for a drug-related offense.
Okay.
So for possession of a narcotic, you could participate in the Section 17 program. Again, you'd be placed on probation for a period of time. You would not plead guilty to any charge, and at the end of that probationary period, and any fines and costs associated with the program, the charge would be withdrawn and then expunged from your record.
Okay. And this is something they could hire a private attorney like you, a criminal defense attorney, to
Yes.
accomplish for them?
Yes.
Okay, before it gets to the conviction stage?
Yes.
Right, okay. So I think we talked about the length of the suspension, 6 months. It Could it be longer? Is there anything else more to understand about that?
For a first conviction, it's 6 months.
Okay.
Now, if there's a repeat conviction, there would be an additional time period. I believe the second time you're convicted of a drug-related offense, your license suspension would be a 12-month suspension at that point.
Wow, significant. What other consequences would people be unaware of for some drug-related offenses, in addition to driving? Is there anything else that you come across in your practice that surprise the clients when they're charged with a drug-related crime?
There's a few things that typically surprise some clients. One being clients who maintain a permit to carry a firearm.
Okay.
There's been a few instances in the past where a client's permit to carry will be revoked because of a pending criminal charge. Once that criminal charge is cleared up and they were found not guilty, the firearm permit was still not returned to them by the state, which creates a few issues there, but it's an unintended consequence of a charge. Another unintended consequence of now this is a DUI offense, not
Okay.
not a drug offense, would be the inability to enter the country of Canada.
Okay.
In Canada, a DUI is considered a felony, and a non-resident cannot enter Canada having been convicted of a felony.
Okay, and just so that we're clear on what a DUI means in Pennsylvania, what level of offense is it here?
In Pennsylvania, first offense DUI is a misdemeanor.
Okay.
Yeah. So it doesn't rise to the level of felony. And in Pennsylvania, a misdemeanor would be any crime that the penalty for which is less than 2 years of incarceration.
Okay, and then above 2 years would be a felony.
It'd be a felony level offense.
Okay. We're going to take a short break now, but when we return, we'll talk to Attorney Mike Niznik about some other issues in the criminal law, including the issue of cash bail, and we'll continue talking about DUIs to some extent too, since that's unfortunately still always an issue of concern to the public. So we'll be right back.
Wake each morning and get lost in the adventure, knowing that you will be ready for wherever the day takes you. Learn from those willing to teach. Their wisdom and their strength will become yours. They will impart to you a tradition of education nationally recognized for its value. A tradition worthy of your best efforts. As young men and women of LaSalle, we will invest in you the guidance to blaze your own path. To go forth into the unknown with new certainty. To realize your full potential as professionals, as leaders, as citizens. To take up your place as the accountants, speech therapists, journalists, and CEOs of your generation. To impact this city and the world beyond. These adventures are yours, and you are ready for them. Explorers are never lost.
Welcome back to People's Law. I'm your host, Bob Coco. This show is designed to improve the average person's basic knowledge of the laws that most affect their daily life. And we're back with Mike Nisnik, a criminal defense attorney in Philadelphia. I'm sorry, Mike, I skipped our usual introduction. If you'd like right now, you could tell us a little bit about your background, where you went to school and where you currently live and your area of practice. You talked about, but bears repeating. Go ahead.
Sure. So as an undergrad, I went to Penn State, and for law school, I went to the Duquesne University of Law. I now live in Philadelphia with my family, and I practice in the area of criminal defense.
Okay. And Duquesne, for people who may or may not know, is in Pittsburgh.
It is.
So we'll give you that one. You stayed in Pennsylvania. So. Okay, so we were talking about DUIs, and of course, as I said before, the topic of the show is to try to have people understand areas of law better that they may be familiar with. And DUI is something that people are familiar with. But I think the average person's understanding of when you would be charged with a DUI would involve drinking sometime, relatively close to the time you're operating the vehicle, maybe within the last hour or hours, or at least the same day. But let's talk about that, because I think you may have something to share that could alter people's understanding of and help them understand how their actions, even for a longer time period, can get them in danger of being charged with a DUI.
Sure. So one thing to keep in mind is, as it relates back to the marijuana segment, marijuana stays in your system for an extended period of time, sometimes up to 30 days.
Okay.
And when you're charged with a DUI in Philadelphia, sometimes they will request your blood instead of a breathalyzer, for example. And when they request your blood, if you've smoked marijuana or used marijuana in some other way, within the past 30 days, that marijuana will show up in your blood as an inactive THC metabolite, an inactive marijuana metabolite. And currently under the laws in Pennsylvania, they're able to charge a DUI as a DUI with both the active metabolite of marijuana, for example, when you're still under the influence of marijuana, and the inactive metabolite of marijuana. There's no distinction in terms of the way they charge the offense. So one thing to keep in mind is an individual could theoretically go to Colorado and smoke marijuana 25 days ago, come back to Philadelphia and be lawfully operating their vehicle. And if the officer has reason to believe that that individual is under the influence, they could request blood, and if marijuana is found in that blood, even the inactive metabolite, that individual could be charged with DUI.
So that's true even if the blood doesn't reveal a level of alcohol that would allow someone to be charged?
Yes.
So it could just be the marijuana?
It could just be the marijuana.
So just a suspicion of driving under the influence can yield a result that's unrelated to alcohol?
Yes.
But still detrimental in terms of criminal charge?
Yes.
Well, that's important to understand. I wanted to backtrack, though, based on something you just said about THC in marijuana. So we were talking about medical marijuana. THC is the property that allows one to get high or alters the brain chemistry that we associate with being high. Does medical marijuana have that same chemical property, the THC property?
I believe it does.
Okay.
I don't have a medical marijuana card, but I believe my belief is yes.
Okay, but a client is never presented with that issue yet.
I have not yet been presented with that issue, no. And again, the medical marijuana program just started in 2018, so I have yet to have a client who's been charged with a DUI who actually has a medical marijuana card.
So it sounds like a good idea if someone is using medical marijuana that they carry that card with them at all times, especially while driving.
Yes.
If that's a result that they experience. Not being a criminal defense attorney myself, I was unaware that blood could be taken at the time an officer stops you. So breathalyzer is the only form of testing that I was aware of. How's blood taken after one is arrested?
Sure. So when you sign up for your driver's license, perhaps when you're 16 years old, you actually sign a document acknowledging that you agree to give your breath or your blood if there is reasonable suspicion of the officer to believe that you're operating under the influence. If you refuse to give your breath or your blood, the PennDOT will suspend your license for a full year, automatic suspension based on a refusal. So there always becomes that question, do I give my blood or not? The answer is it really depends on the circumstances of the case.
Well, a couple follow-up questions then on the taking of blood. Does the officer have the capability with a testing kit to take it right there, or does you have to be brought to the station to?
You're typically taken to a hospital, and the blood is taken by a trained either police officer or nurse who would then come to court and typically testify how they took your blood, when they took your blood, those types of things.
Is there any grounds that you could have to, and that would form the basis of a successful defense that you can refuse, if stopped, to give breath or blood?
Certainly, you have the absolute right to refuse to give your breath or your blood at any time. The only issue is if you do refuse, there's an automatic license suspension, and the offense is considered a highest tier offense. So in Pennsylvania, there are 3 different tiers of blood alcohol levels that make up the DUI sentencing, and if you are a refusal, you're automatically placed in the highest tier.
So you're really upping the ante. But what are some facts potentially that would warrant taking that serious stand?
Sure. So the officer needs what's called reasonable suspicion to request your blood and take your blood. And if the officer does not have those, or does not have that set of facts, certainly, and in court, you could argue that the blood was taken improperly.
Okay, so it could be a situation where you're just driving in your neighborhood and you feel like you're being harassed.
Yes.
By a police officer, and in those circumstances, you can, knowing that you haven't smoked marijuana within the last 30 days or had a drink recently, protect your rights in that way.
Yes.
Sometimes you may take that serious stand. Okay. In addition to DUI charges, what other issues arise at the defense level that people may not be aware of, other than what we just discussed? Is there any other defenses to DUI charges that people should be aware of?
Well, I think a DUI case is very fact specific. So in terms of defenses, it really depends on a number of factors. How the stop was initiated, whether it was a checkpoint, a traffic stop, or whether the officer came upon the vehicle after the vehicle was already stopped. And also the circumstances of the driver. I think there's a lot of factors that go into the defense.
It might be something more for a separate
Sure.
show, right? I guess we could get too far into
Sure.
that. So one thing I did want to ask you, because we were talking about the changes in the marijuana laws in Philadelphia and their enforcement, what about cash bail and how that plays into DUI offenses, and the recent development where the DA is not enforcing cash bail for a lot of offenses? So maybe we could talk about it in the context of DUI and generally, maybe start generally and then go into DUI.
Sure.
Yeah.
So the cash bail system, for those who don't know, is a system that if you're charged with a crime, the district attorney's office could recommend that you must post money to be released from prison with a promise to show back up to court. And what they do is they use that money as your guarantee to show back to court. If you don't come back to court, they then will seek to keep that money. The district attorney's office has recently withdrawn a lot of the requirements for cash bail for low-level offenses. For example, the possession of marijuana and DUI.
Okay, and why has it been withdrawn in the case of DUIs that we've just been discussing?
Well, DUIs are considered a misdemeanor under Pennsylvania law, so it would be considered a lower level offense than, for example, a felony. And the cash bail system, there's been a lot of publicity surrounding the cash bail system because For example, a low-level offense like the possession of a narcotic, an individual could be in jail for an extended period of time, months, in extreme cases, years,
Wow.
with the inability to post a small amount of money to be released from prison, sometimes $1,000, $2,000. And this is all without a conviction at this point. They're just charged with a crime. So it really disadvantaged the individuals who were poor.
Yeah.
So I think that's the right step for the district attorney's office to take to pull back on those low-level offense cash bail cases.
Also, now that jail cell could be used by someone who's actually does present a danger to the public by their criminal conduct. So it does sound like a positive advance in the criminal law. Well, we want to thank Mike for coming today and sharing with us your knowledge as a criminal defense attorney in those important and timely areas. So if you're interested in discussing or learning about the topics we've discovered today, you can go to my website, phillyconsumerlaw.com, where I'll have links to videos of our guests. And Mike, if you'd like to share with the viewers your personal information, contact information.
Sure. So you can go to my website, nizniklaw.com, nizniklaw.com.
Okay. And I want to thank everyone for watching and remind you that until next time, remember, take the time to understand and protect your legal rights.